honored to have Ms. Gillian Lam and Mr. James Ng with us here today to speak to us on the topic of arbitration or winding up petition, practical insights on their effectiveness for debt recovery. Let me introduce myself first. My name is Simon Wong. I'm a council member of the Hong Kong Institute of Arbitrators. Today's webinar is organized by HKIArb. I am the moderator for this webinar. Before the start of the webinar, let me first introduce the speakers. Ms. Gillian Lam is a senior associate in the dispute resolution group of Baker McKenzie in Hong Kong and a member of the firm's Women in Arbitration leadership team. He is a fellow of the Chartered Institute of Arbitrators and a member of the Arbitral Women. He is also the Hong Kong ambassador for Arbitration Lunch Match. Gillian's practice focuses on commercial litigation and arbitration in Hong Kong, including general commercial corporate disputes, commercial fraud, and bribery investigations, contentious employment issues. And as for James is also a registered foreign lawyer in the dispute resolution group of Baker McKenzie in Hong Kong. He is a fellow of the Chartered Institute of Arbitrators and a Hong Kong International Arbitration Center accredited tribunal secretary. James has over 8 years of experience in international arbitration. His practice covers commercial, construction, hotel management, IP, M&A, and shareholders disputes. Before joining Baker, James worked at the Hong Kong International Arbitration Center, overseeing more than 300 arbitration cases, with a focus on China-related disputes. He has acted as tribunal secretary in high-stakes commercial arbitrations, including emergency arbitrations. May I also remind the participants that during the presentation, they are free to type their question in the chat box, and Gillian and James will answer your question afterwards. So please join us in welcoming Gillian and James. Gillian, the floor is yours.
Thank you, Simon. Thank you, everyone, for joining this talk tonight. Thank you. We're talking about arbitration or winding up petition, practical insights on their effectiveness for debt recovery. So with the introduction, let me just start with telling you that James and I have recently handled a case for a client in a debt recovery case. In that case, the debtor had acknowledged the debt, and the debt was subject to an arbitration clause. We issued a statutory demand, and eventually a winding up petition was made against the debtor. And the debtor commenced arbitration on the basis that there was a cross-claim and sought to stay or dismiss our client's petition. This prompted a very interesting question for us when we acted for the client. We believe this might be an interesting topic to you all as well. So thanks for joining this seminar. Now, very often in debt recovery, we may issue a debt demand letter, or for more teeth, a statutory demand, so that if the debtor company fails to pay within 3 weeks, it will be wound up. Sometimes the debtor will continue to ignore us until we issue a winding up petition to wind up the company. To the debtor company, a petition is an ultimate threat, as it will mark the beginning of the end of the company. And it affects the business in a number of ways. The banks may freeze the bank accounts. Events of default in various agreements, existing agreements, may be triggered, causing an havoc to the business. For a debtor company, if it wishes to continue business, it will either immediately pay off the debt or try to challenge the debt. So today in this seminar, we're talking about the situation where the debtor company challenges the debt on the basis that there is an arbitration clause in the agreement giving rise to the debt, and the debt is disputed. Courts in Hong Kong and other jurisdictions heavily debated on the approach on this very question. Should the court stay or dismiss the petition in light of the dispute resolution clause? What are the policy considerations behind the approaches? And what are the relevant factors which will become part of the court's discretion? And recently, in May 2023, the Court of Final Appeal in Gai Kwok Hong Lam has authoritatively determined this approach in the context of an exclusive jurisdictional clause. So does it apply to arbitration too? You'll find out in this seminar. So the purpose of this seminar is to revisit some of the important cases in Hong Kong and some other jurisdictions and discuss the way forward and practical tips in handling similar cases. So here's the agenda, and we'll start with debt recovery options first. Now in this slide, this shows you the way we normally go about in recovering the debt. First off, you start with a demand letter. Second, if there's an arbitration clause, you might crystallize the debt by getting an arbitral award. Thirdly, through the litigation path, you could get a summary judgment on the basis that there's no defense. Finally, through the insolvency regime, you can first issue the statutory demand, SD. If the debt is not paid within 3 weeks, you can petition to wind up the debt. Owing to the commercial pressure, the debtor may immediately pay up. The statutory statutory demand regime is available in a number of common law jurisdictions, including Hong Kong, UK, and Singapore. And this is applicable to both winding up of companies and bankruptcy of individuals. The statutory demand regime creates a deeming provision whereby the company is deemed to be unable to pay its debt if the demand exceeded a certain amount and that demand is served on the company, but the company failed to pay within 3 weeks. Each of these jurisdictions here has its own similar provisions, although a different limit. These various jurisdictions each have encountered similar questions in cases where a creditor petitioned to wind up a company on the basis of an undisputed debt. Yet, the debtor challenged the petition by saying that the court should go to court or arbitration because there's a jurisdictional clause or an arbitration clause. Today, we focus on the interplay between the insolvency regime and the arbitration route. Focusing on the winding up and arbitration, here are the timelines for recovery. For the insolvency regime, you issue a statutory demand when ignored. Oh, sorry. Okay. So I was told to switch on my camera because that other camera doesn't work. So hi, everyone, those who are online. So let's go back to this slide, ways to recover debt. So these are the timelines. For insolvency regime, you issue a statutory demand. When ignored or not challenged, you issue a petition after 3 weeks for the company to be wound up. Due to the commercial pressure, a solvent commercial company will very often respond to pay the debt once the statutory demand is issued. Or in some cases, once the petition is issued, the debtor may negotiate with us to adjourn the hearing to gain some time to repay. And in a case that I've handled, our client recovered its debt fully after a few adjournments. However, using the insolvency regime is a double-edged sword. If the case doesn't settle with a repayment, the creditor will become an unsecured creditor sharing the distribution pari passu with the rest of the unsecured creditors in the end, and the repayment will be delayed until the liquidator declare a dividend. Very often, the creditors are left with only a fraction of their original debt. And in my experience, it may take years for liquidator to investigate and declare the dividend. On the other hand, if the creditor brings a petition knowing that there is a bona fide dispute over the debt, it risks being liable to pay the debtor's costs on an indemnity basis. Therefore, the use of the insolvency regime to collect debt is usually a last resort and should not be taken lightly. However, in case where the debt is undisputed or without a bona fide dispute, or where the company is actually solvent or likely to be solvent, the statutory demand may well do the trick.
So if winding up is not an option for the client, then what the creditors will ordinarily do is to pursue the dispute resolution mechanism in the contract. And very often that will be arbitration, especially if you have a cross-border disputes. And also that would be ideal if you want to get a legally binding and enforceable decision. So if you look at the slide here, the timeline usually commences when you submit the arbitration to the applicable rules or the institution by submitting a notice of arbitration. You'll then go through the process to constitute a tribunal, to submit pleadings and also exchange evidence. And then that will lead to an evidentiary hearing and hopefully an award at the end of it in your client's favor. And this process can take about 1 to 2 years based on the HKIAC statistics, but there are certain ways you can shortcut the process. So if you, for example, adopt the expedited procedure in appropriate cases, or there's even a new mechanism now for the early determination procedure. So that's quite, quite similar to the summary judgment process in the court, where you can actually get a decision if there's a manifestly without merits on the issue of fact or law. So these are some things that you can try to force an early settlement, or you can even truncate some of the issues to be determined at trial. So after you've obtained the award, then you have to enforce the award in the Hong Kong courts as a Hong Kong judgment. And from our experience, we've done a case where we can actually get an enforcement order within weeks if it's uncontested. But if the debtor contests the award or try to set aside the enforcement order, then that can drag on for months or even years. And only after you recognize the award as a judgment in Hong Kong, then you can start to go through the execution proceedings to go after the debtor's assets. So as you can see, it's quite a long process to the pot of gold at the end. So some creditors might actually opt to go with the winding up option in hopes of winding up the company quite quickly and join in the liquidation process. But as you'll see from the slide, the answer is not that simple.
So let's go through some of these cases that we'll talk about on DR clauses' effects on insolvency proceedings. So this slide here is just an overview of the cases which show different approaches in different jurisdictions towards the ongoing debate on the effect of DR clauses in insolvency. We'll cover some of these cases in this seminar, but what I want to highlight to you here is that in each of these jurisdictions, there are cases which involve the exclusive jurisdiction clause, EJC, which I'll talk about later, and also arbitration clause. As for this slide, as I mentioned in the beginning, there are two heavily debated approaches between judges and practitioners in the circumstances. Here's a summary of the positions of different cases before the Guy Kwok Hong Lam case, the CFA decision. So on the left of the summary table is the established approach, which requires the debtor to show a bona fide dispute on substantial grounds to dismiss the petition. On the right here, we call it the Lasmos approach. Oh, sorry. In Lasmos 2018, Justice Harris held that petition should generally be dismissed if the disputed debt is subject to an arbitration clause. So this is called the Lasmos approach. And you can see the Guy Kwok Hong Lam is also underneath these sort of approach. It's very similar. It just says that you should stay or dismiss the petition if there's an EJC. So it shows the debate here. There's various cases in different jurisdictions adopting the two approaches in the different contexts, and we'll cover these cases later.
So it'll be quite helpful to start off with looking at what exactly is the established approach. So this is the position in Hong Kong and also other common law jurisdictions, and it applies to both bankruptcy and also winding up orders. So the starting point is that unless there's a bona fide dispute, if there's a bona fide dispute on substantial grounds, then the petition should generally be dismissed. And the idea is that because the creditor has already proved to the court that there's a statutory ground to wind up a company, the onus shifts on the debtor to show why a winding up or a bankruptcy order shouldn't be made on the basis of a tribal issue, or what is known as bona fide dispute on substantial grounds. So as you can see on the slide, the onus is on the debtor, shifts to them to show with evidence why there's a bona fide dispute. And you need to provide believable evidence to the court to show that there is indeed a bona fide dispute. So that is basically where the starting point is before all these other jurisprudence came into place. And what really kind of kick-started this debate between winding up petition and arbitration agreements is the English Court of Appeals decision in Salford Estates back in 2015. So in this case, it's quite a landmark decision because it's basically the basis for all the leading cases in Hong Kong and Singapore, which we'll look into later. And we'll also look into this decision in detail, but essentially the English Court of Appeal departed from the established approach and they adopted what's called the Salford approach, where as long as there's an arbitration agreement and the debt is not admitted or if it's disputed, then that's already a dispute in itself. And the winding up petition should be either dismissed or stayed unless there's exceptional circumstances. So the court still has a jurisdiction in exceptional circumstances to see if there's a bona fide dispute on substantial grounds. So it retains a certain jurisdiction, but this is a default position. Unless there's a exceptional circumstance, the petition should be generally dismissed or stayed. And that's basically followed in Singapore as well. In the 2020 Singapore Court of Appeal decision in the Dayang group. So they've adopted what is called the prima facie standard. So again, the proceedings will be dismissed if there's a valid arbitration agreement and the dispute falls within the scope. But unlike Salford in the English Court of Appeal, they adopted a different exception called abusive process. So they wanted to adopt that in Singapore, which in its view is a better, it better coheres with the whole law of civil procedure. So basically the court will ascertain if the proceedings in question is an improper use of its machinery. So they want to see if they retain a jurisdiction in cases where there's abusive process. So for example, if there's already admitted debt, if the debtor already admits to the liability in quantum, but they still try to raise the defense anyway, that could amount to an abusive process. But there is an exception from the Singapore court. If the petitioner can show there's a legitimate concern, and there's no triable issues, then they could stay the proceedings rather than dismissing them outright. And importantly, the decision in Singapore held that the standard would apply either to a debt or a cross claim, which is something that's adopted into the Hong Kong jurisprudence later on.
So now let's look at the Hong Kong position. So the basic point I want to show you here is the pre-Gai Lam and the post-Gai Lam judgments. The takeaway here is before Gai Lam, the Lasmos approach has been doubted in certain, in the High Court and also in the Court of Appeal. And after the Gai Lam's decision, there's still a debate as to whether Gai Lam applies to arbitration. So there's still debate. That's all I want to say on the Hong Kong position.
Right. And we'll now look into the recent Hong Kong cases that led to where we are today. But I think it will be helpful to start off with an examination of the Salford Estates case that I mentioned, because this is really what kickstarted the whole debate about arbitration agreements and winding up petitions. So basically, the facts are quite straightforward. So there's an arbitration clause in the lease, and there was an arbitral award that was obtained by the lessor, which required the lessee to pay certain sums to the lessor. And the lessee in this case failed to pay the amount in full. So the lessor submitted a statutory demand and then subsequently a winding up petition. The defense raised by the lessee in this case is that the winding up petition should be stayed or dismissed because there's an arbitration clause and because the lessee objected to the petition on the basis that there are certain sums were payable under the award, but there are other sums that the lessee disputed. So they don't agree to pay those sums. And they said that those disputes should be referred to arbitration. And the Court of First Instance stayed the petition, and this decision was appealed to the English Court of Appeal, which upheld the decision to stay the petition. So the relevant rulings, or basically the key takeaways from this case is that first of all, under the Arbitration Act, there's usually an automatic stay if there's a dispute referred to arbitration. But a winding up petition doesn't fall within that category because it's not a claim for the payment of a debt. Even if the winding up order has the effect of determining a claim, the English Court of Appeal said that that's not a claim that falls within the scope of the Arbitration Act. So there's no automatic stay of proceedings. But the court should still exercise its discretion to stay the proceedings because there's an arbitration agreement. And that's consistent with the pro-arbitration stance in England and Wales. And that is also respecting the parties' chosen method to resolve their disputes. And importantly, the court also made an observation that this bona fide disputes approach, which is what Salford said, that unless there's a bona fide dispute as to the debt, then the petition should generally be stayed or dismissed. Because if you use the established approach to look into whether there's a bona fide dispute, that's essentially carrying out a summary judgment type of assessment. And it's not in the place of the company's court to do that. It's for the arbitral tribunal to look to see whether there's a bona fide dispute. So that was sort of the policy reason as to why Salford Estates decided to stay the petition.
Thank you, James. So now let's take a look at the Lasmos approach. So in this case, Southwest Pacific Bauxite Hong Kong Limited, the petitioner is called Lasmos. Therefore, this is called the Lasmos approach. The petitioner issued a petition to wind up the company on the basis of an unsatisfied SD. The SD sought payment over an agreement which contained an arbitration clause. The company disputed the debt and sought to strike out the petition. And the issue is the impact of the arbitration clause in the agreement and on the exercise of the court's discretion to make a winding up order. Justice Harris here dismissed the petition, departed from the established approach, and followed the Salford approach. So this is called the new Lasmos approach. So what the approach is saying is that the winding up petition should generally, subject to exceptional circumstances, be dismissed if, number one, the company disputes the debt relied on by the petitioner. Second, the contract under which the debt allegedly arises contains an arbitration clause covering any dispute relating to that debt. And finally, that the court the company takes steps under the arbitration clause to commence the contractually mandated DR process, which may include preliminary stages such as mediation, and files an affirmation demonstrating that it has done so. Now, the policy consideration of Justice Harris is mainly the pro-arbitration approach that's taken by the Hong Kong legislation and the pro-arbitration stance of Hong Kong court. And he says that the established approach gives no way to these policies. And second, he thinks that the company's court should hold the creditor to his contractual bargain to resolve this dispute. And so these are some of the policies, and we can talk about policies later on. But just to see how other courts treat this judgment. The first one would be an arbiter statement from the Court of Appeal in Bakar Chong. Madam Justice Kwan has some reservations on the Lasmos approach. What she said was that the court retains a discretion under this insolvency legislation, which should not be exercised only one way, which is the Lasmos way, to substantially curtail the right of the creditor to present a petition, although she acknowledged that considerable weight should be given to the factor of arbitration. So, and secondly, she again commented in the Sit Kwong Lam case on the Lasmos third requirement that there should be an affirmation showing that steps has been taken under the arbitration clause. She thinks that is a sensible requirement to demonstrate to the court that the debtor has a genuine intention to arbitrate.
The court of first instance after these decisions and also after Lasmos did further consider Lasmos, and in the case of Dayang in 2020, they've sort of stepped back from the Lasmos approach and suggested that maybe the court should reconsider the established approach. So in this case, it was a charter party dispute, and there's a Hong Kong ad hoc arbitration clause with English laws to apply. The company in this case didn't dispute the debt, but argued that the petitioner has some responsibility for the company's loss, and sought to rely on the arbitration clause to resolve that dispute. So in this case, the court found that the company actually didn't rely on the third step of Lasmos to take steps to commence the arbitration. So the winding up order would have been made anyway. But the court of first instance looked at the Lasmos approach and made some comments. So it stated that the court actually does have a flexible discretion to make a winding up order, and it sort of criticized the Lasmos approach because it is the court calls it an unprecedented fetter on the court's flexible discretion. And the court believed that the established approach should actually apply in all cases, whether or not the dispute actually arose from a contract incorporating an arbitration clause. While the fact that the arbitration proceedings have commenced may be relevant evidence that there's a bona fide dispute, it's not alone sufficient to show that there's a bona fide dispute on substantial grounds. So it sort of required the debtor to prove that, or to show that there is indeed a bona fide dispute. And the court actually said that where the creditor petition in cases where they knew that there was a bona fide dispute on substantial grounds, then the creditor might actually be liable to pay the debtor's costs on an indemnity basis. And the court actually mentioned about the tort of malicious prosecution as a possibility if the creditor decides to proceed with the case anyway, knowing that there's a bona fide dispute. And in subsequent decision in 2022 by the CFI in Re Hong Kong Baiyuan International Business Company Limited, the court also followed the established approach where the company was ordered to pay the debt within 14 days. Otherwise, it'll be wound up, even though there's an arbitration agreement. And Madam Justice Linda Chan said in that case that the discretion to wind up a company is not exercisable only one way as in Lasmos. And this was followed in subsequent decisions in 2022 in DCKD and also Repan Sutong, where the court said that it will only require the parties to resolve the dispute through arbitration if there's a genuine dispute or a bona fide dispute on substantial grounds. So it seems that recent CFI decisions before Gillian in 2022 have also started to question whether the Lasmos approach should be strictly followed in cases where there's a winding of petition and also an arbitration agreement.
So let's go to the main case, the Gai Kwok Hong Lam case in 2023. But we'll start with the facts and go through the CFI and then Court of Appeal decisions as well. Now, in this case, the petitioner advanced term loans to a company controlled by the debtor who acted as a guarantor of these loans. The agreement contained an EJC in favor of New York courts. The petitioner served an SD on the debtor, requiring him to pay the outstanding principal and interest. It then presented a bankruptcy petition as the debtor did not comply. The debtor opposed the petition in Hong Kong by arguing, amongst other things, that the petitioner should be required to litigate the dispute in New York before coming to Hong Kong to invoke the bankruptcy regime. Now, in the court of first instance, Madam Justice Linda Chan applied the established approach, notwithstanding the existence of the EJC. She says that the creditor has locus to present a winding petition if there's no bona fide dispute on the substantial grounds in respect of the debt. The fact that the parties have agreed to an arbitration clause or an EJC, this is only a factor which the creditor, which could be taken into account by the court in exercising their discretion whether to consider the petition. And an EJC does not per se prevent the company's court from considering the issue whether the creditor has locus to present the petition in the first place. This is because unless and until the debtor is able to demonstrate to the court that there's a bona fide dispute on substantial ground in respect of debt, there's no proper basis for the company to contend that there is a dispute which must be litigated in accordance to the contractually agreed forum. In other words, it's pointless for the creditor to first obtain an award where there's no real dispute on the debt. Then subsequently, in the Court of Appeal, they uphold the effect of the foreign EJC and held that the court should exercise its discretion to dismiss or stay the action brought in breach of the EJC unless there's strong reasons not to do so. Now, the Court of Appeal first examined the strong cost test in a normal case involving an EJC. And then it considered that EJC is engaged in this case because under the EJC, there's a negative aspect requiring the parties not to bring an action elsewhere. And this prescription is engaged when parties seek a judicial determination on the right of parties under the agreement and finding against the company that its defenses do not raise any bona fide dispute is in itself a determination of the dispute. And it also held that the same approach, therefore, should apply to the EJC in winding up and bankruptcy petition as in just an ordinary action. The court concluded that where the petition debt is disputed and where the parties are bound by an EJC in favor of a foreign court, the petition should not be allowed to proceed pending the determination of the dispute in the agreed forum unless there are strong reasons otherwise. However, the minority in Court of Appeal, Justice Chow, was not prepared to follow the Lasmos approach, and he thinks that the EJC shouldn't be given conclusive weight but just a factor. So in short, the comparison between the CFI with Madam Justice Linda Chan, who thinks that the ECJ is not engaged because the very conclusion that there's no bona fide dispute means there's no dispute to refer to the foreign court. And this relates actually to the positive aspects of the EJC to submit the dispute to the exclusive jurisdiction of the agreed forum. No dispute, no bona fide dispute, no need to go to court. That's as easy as that. But this Court of Appeal, the majority and the Court of First Instance, Court of Final Appeal find that the ECJ is engaged because they focus on the negative aspects of an EJC. The very determination that there's no bona fide dispute in a summary judgment-like manner contravenes the negative aspects of the EJC. So finally, let's look at what the Court of Final Appeal say. They basically agree with the Court of Appeal and think that the established approach is not appropriate when exclusive jurisdiction clause is involved. And the agreement by the parties to an EJC would affect the court's exercise of discretion to decline to exercise its jurisdiction. Where the underlying dispute of the petitioning debt is subject to an exclusive jurisdiction clause, the Court of Appeal say the court should generally dismiss the petition and hold the parties to the contract unless there are countervailing factors such as the risk of insolvency affecting third parties or disputes that borders on the frivolous or abusive process. And it also says that there's no need to think about the interaction between the non-discretionary provision applicable to arbitration clause with the statutory jurisdiction of the court in bankruptcy. Now, here in this next slide, I'm just trying to show you the interesting distinction between what the majority say in the Court of Appeal and what the minority say. The majority, led by Mr. Justice Godfrey Lam and Barma, they talked about similar situations as where the minority says about the relevant wider consideration. So what the majority considers as strong reasons not to dismiss the petition is very, very similar to what the minority says, where they consider as wider consideration, which just needs to be taken into account as a discretion. Both took into account whether the company is massively insolvent or obviously insolvent, and they also think about whether there's a need to preserve assets or investigate wrongdoings. What this really indicates is, although the justices may have termed the factors differently, in the end, the court still has to exercise its discretion, taking into account all these factors. Indeed, the Court of Final Appeal acknowledged that the approach to decline to determine the bona fides and substance of the dispute is in some sense multifactorial. So whilst the strong case is indicative, it should not obscure the range of consideration relevant to the court's discretion. So from us, from a practitioner's point of view, the petitioner will always try to bring to the court's attention these exceptional circumstances in order to get the winding up order. Next, this is the diagram which I'm very happy to present to easily tell you what's the difference, the established approach and the Gillian approach. With the established approach, there's a shifting of a burden. First, in the established approach, the debtor needs to show bona fide dispute on substantial grounds, whereas in the Gillian approach, it would become the petitioner's burden to show that there's a frivolous defense. And so here you see on the left and on the right. And also, the threshold has become higher after the Gillian EJC approach. That is, the frivolous defense is higher to prove. So I hope you remember this slide. It's easy to remember. So after the Gillian's judgment, there's a judgment from Madam Justice Linda Chan in Resimplicity. And in this case, the company guaranteed the repayment of certain convertible bonds, but the issuer failed to repay on maturity. The petitioner issued an SD and later petitioned to wind up the company. The company failed to file an evidence in opposition in time and was given leave on the condition they pay the full debt into court. the company failed to comply with the condition, and the court refused to grant an extension of time. So the court actually granted the winding up order on the basis that there's actually no evidence in opposition. However, for the sake of completeness, the court also considered the company's ground of opposition, and the company basically argued that the underlying bond instrument and the guarantee both contained an arbitration clause, and thus this should go to arbitration. The petitioner, however, relies on Lasmos and contend that the court should not stay the winding up petition because the company had not taken steps to commence arbitration as per the third requirement of Lasmos. And they say, and the petitioner also say that the CFA judgment in Gillian didn't change the approach in Lasmos at all. So what Madam Justice Linda Chen observed as an arbiter in this case is basically the ratio in Gillian does not apply to arbitration. It only applies to EJC. And Gillian did not lay out any general rule that if the agreement gave rise to a petitioning debt contains an arbitration clause and there's no supporting creditor, the court must dismiss or stay the petition. Sorry. Going back. And where the company raised a substantive defense to the petitioning debt, the court should consider whether the defense is one which can readily be shown to be wholly without merits. If so, the defense is one which borders on the frivolous or abuse of process, even if the Gillian approach applies. And there's no basis to require the parties to refer the dispute to arbitration when basically there's no genuine dispute. As to the next case, anti-pharma, the court adopt a very similar approach. Sorry. So in this case, the petitioner sought to wind up with the company based on an undisputed debt which arose from a supply agreement containing an arbitration clause. The company did not dispute the debt, but had acknowledged the debt. It opposed the petition, however, on the basis of a cross-claim against the petitioner in a separate but related agreement. And the debt was secured by the amount paid in court. So basically, the full debt was paid into court in this case. What the ruling was that the petition is adjourned to give the company opportunity to pay the debt, and cost was awarded to the petitioner. So the court basically restated her own ruling in simplicity and held that the company should not be allowed to withhold payment until the determination of the cross-claim in the arbitration. The court held that the debt and the cross-claim did not arise from the same agreement and were basically completely unrelated to each other. And the cross-claim would not even stifle the company, which is, according to the company itself, is massively solvent. So, and so it's required to pay the debt. So on Arbiter, the court also considered that the company, in any event, didn't discharge the burden, showing that there's a serious cross-claim against the petition. So noting is adopting the advanced approach for arbitration clause. And so the court also held that there's no valid ground for the company to oppose the petition, adjourn the petition, and awarded the cost to the petitioner. And we acted for the petitioner, by the way.
So at the risk of further complicated things, so we've seen two decisions from Madam Justice Linda Chan post the Gillian decision that held that the established approach applies even though there's an arbitration clause. Now, we have a latest decision from Mr. Justice Harris. It came out quite recently, the Shandong Chenming Paper Holdings Limited case. And I think for arbitration practitioners, they'll be quite familiar with this case. It's the dispute between Arjo Wiggins and Shandong Chenming. They have quite a lengthy history of dispute between them, and some of the cases have gone to the CFI and even to the CFA. But the relevant case here has to do with the petition that was filed by Arjo Wiggins all the way back in 2017. They wanted to wind up the debtor company, Shandong Chenming, because they failed to pay an arbitral award that was issued for the first arbitration. And because of the other disputes I mentioned, the court stayed the petition pending the resolution of those disputes. And in June last year, the debtor company actually commenced a second arbitration against the petitioner, advancing claims under the same agreement that gave rise to the first arbitration. So it's essentially a cross-claim. and the company's cross-claim exceeded the petition debt that's subject to the winding up petition. And the hearing for the second arbitration is due to take place in May next year. And now the company, having commenced the second arbitration, they're using that as a reason to try to dismiss or adjourn the petition that was filed back in 2017. They tried to rely on Guy Lam, and they argue that because the cross-claim exceeded the petition debt, and because the cross-claim is supposed to be determined in the arbitration, the winding up petition should be dismissed. So in this case, Mr. Justice Harris held that the petition should be stayed. He found that the same principles in Guy Lam that applies to an exclusive jurisdiction clause should also be adopted to arbitrations. So specifically, the petition should be either dismissed or stayed if there's a cross-claim that's part of the arbitration agreement and that exceeds the amount of the petition debt. So Mr. Justice Harris basically said that Madam Justice Linda Chan in Simplicity was wrong. And basically, there's no distinction between a claim and a cross-claim, which is the same position in Singapore in Anang Group that I mentioned before. One of the parties tried to argue that there's some kind of like legal gap or lacuna from the appellate judgment in Guy Lam, but Mr. Justice Harris said that that's sort of artificial and basically rejected that argument that there's some kind of distinction between a claim and a cross-claim. And also in this case, because there was no evidence of abuse of process that was put into court, there were some delays in bringing the cross-claim, but that in itself is not, it doesn't amount to the standard of an abuse of process. So basically in this case, the court decided to stay the petition instead of dismissing it, because the court actually said that this is a case that has a long history. So he wanted to preserve actually the date of the winding up petition in case it becomes relevant later on. So it's quite a special case where the court decided to stay the petition rather than the usual decision to dismiss.
So here's another graph that I'm really proud of. It's a scenario testing graph for petitioners to use. The vertical axis here is a solvent. It's concerns the solvency of the company. On the top, solvent, on the bottom, insolvent, and the horizontal axis represents the merits of the dispute of the debt. On the right, we have frivolous defense. On the left, we have bona fide defense. Now, we assume in this graph that there are no other exceptional circumstances requiring the court to wind up the company. Just this helps you to determine. Now, we have some very obvious conclusions on the top left and the bottom right. When you have a solvent company and bona fide dispute, obviously the petition should be dismissed. Bottom right, you have a frivolous defense, insolvent company, obviously the winding up company order should be made. These are very straightforward. Now on the top right, where you have a frivolous defense or a cross-claim, but a massively solvent company. This is exactly the case of NT Farmer, where Justice Linda Chan essentially adjourned the petition to allow for repayment and awarded costs to the petitioner. The alternative to this is that the court actually has jurisdiction to release payment into court to achieve justice between the parties under Order 22A, Rules of High Court. So I believe I want to advocate that this is a fair way of resolving a situation like this. In fact, legitimizing the route for creditors to commence winding up proceeding in order to recover debt, where the debt is essentially undisputed. Now we have the bottom left, where the debtor has a bona fide dispute, meaning it doesn't have locus to bring the petition in the first place, and the petition ought to be dismissed. But if there are other creditors, they might have a dispute and they could substitute the petition to continue the proceedings. So remember this slide. Anything to add? Okay. So this is another summary slide.
Hopefully this will be the last. Yeah, hopefully this will be the last summary table that you see, because it's post Guy Lam. So it basically has summarized the decisions that we've talked about, and it basically succinctly summarizes the approach taken by each jurisdiction. So if you look at exclusive jurisdiction clause, so the established approach that's followed actually in the UK, they still adopt the established approach. And this is based on a very old decision in 2001 called BST Properties. So there was a recent decision called City Gardens that was considered by the English High Court to see whether they'll follow the established approach as held by the English Court of Appeal in 2001, or follow the Gillian decision in this year. So they've actually did consider Gillian, but as a matter of precedent, they decided to follow the higher court's decision in the English Court of Appeal. So they didn't follow Gillian in this case. So it seems for the time being in the United Kingdom, they'll follow the decision to adopt the established approach for the exclusive jurisdiction clause. And for Hong Kong, it's basically the Gillian decision where they will adopt the Lasmos approach. And that's also the case in Singapore. They do have a decision back in 2018 that follows the Lasmos approach. And Singapore seemingly have sort of adopted the same approach for both exclusive jurisdiction clause and arbitration clause. As you can see down there for Dayang Group, that's also following the Lasmos approach. And that's also been followed in a BWG case, which is decided around the same time as Dayang Group. For arbitration clause, UK is also quite settled because we have the Salford Estates case, English Court of Appeal, and that's also followed subsequently by the High Court in Telnik. So it's really only in Hong Kong that the situation for arbitration clause is sort of in flux. You have these cases before Gillian that have followed either approach. You have Lasmos, which came out in 2018, but as you have seen from the CFI and CA, there are obiter comments and also judges have followed different approaches. And after Gillian, we've seen the cases that we discussed. Gillian talked about Simplicity, Anti-Pharma, where Madam Justice Linda Chan followed the established approach. And I've just talked about Mr. Justice Harris' approach in Shandong Shenming. He tried to argue that Gillian actually does apply to arbitration clause. So this is sort of where we are, at least as far as Hong Kong is concerned. For arbitration clauses, it's still sort of in the, the jury's still out, but there may be an argument that the authorities here suggest that the courts, whether it's in Hong Kong, Singapore, or elsewhere, they do try to adopt an approach that's consistent, whether it's exclusive jurisdiction clause or arbitration clause. So it wouldn't be surprising if the appellate court in Hong Kong later on also decides to follow the same approach, but that remains to be seen.
So here's just a summary of all the policy considerations mentioned by all these judges in these various cases that both me and James has talked about. On the established approach, we have first, insolvency regime as a class remedy. So it's a class action which public interest, so it's very important, therefore we should follow the established approach and allow a creditor to wind up a company if there's no bona fide dispute. And second, the pro-creditor statutory rights. This has been mentioned by Madam Justice Kwan in the Bat Ka Chong case. The third is the pro-court discretion approach, which says the court should not adopt a mechanistic approach or fetter the exercise of its discretion in any way, and should only take into account the DR clause as a relevant factor.
Right. And then on the other hand, you have the Lasmos approach consideration. So first and foremost, even in Salford Estates, they decided to adopt that approach because of a pro-arbitration view taken by various jurisdictions. So England and Wales and even in Hong Kong, we have very pro-arbitration judiciary. So if the parties have agreed on arbitration, that is something that they'll hold the parties to. And part of the reason also hand in hand is the party autonomy to be held to their contractual bargain. So it will be quite unusual for the court to sort of adopt a summary judgment type to look into the dispute as in Lasmos and also in Salford Estates if there's an arbitration clause, because that would actually encourage parties to bypass what they've agreed and go straight to the courts. And also as highlighted in Lasmos, basically, they do not encourage creditors to issue the petition just to recover a debt, because they see that creditors sometimes they don't commence the insolvency proceedings because there's an altruistic concern for creditors as a whole. Like in Gillian, for example, they said that if there's no evidence of a creditor community at risk, if the company doesn't have a lot of creditors, then that is not sufficient to justify why the petition should not be dismissed. So these are sort of the public policy behind winding up petition, the insolvency regime. DR clauses are constantly at clash with each other, and I believe that the courts are trying to find a way to harmonize everything, to find a solution that actually makes sense to both creditors under the winding up regime and also the private arbitration regime.
So we have two case scenarios to talk about. We might only cover one because of the time. So scenario one, A entered into a customer agreement with B, where A opened an online portfolio margin account with B's online broker-dealer platform. The agreement contains an arbitration clause. A traded in a futures product and B issued a margin call in light of an unexpected unpegging of currencies. A failed to deposit funds to resolve the margin deficit, and B liquidated A's position, and A complained of improper handling of its liquidation policy. And B subsequently served a statutory demand on A for the account deficit and interest thereon, and also later filed a winding up petition. A applied to dismiss or stay the petition, arguing that the customer agreement contains an arbitration clause. Now, how will the Hong Kong or the Singapore or the English courts decide on this? We have four options, and we hope that you can all join in with us to let us know what you think the answer is. A, the court has the discretion to examine if there is a bona fide dispute on substantial grounds. Second, B, the petition should be stayed or dismissed unless there are exceptional circumstances. C, the petition should be stayed or dismissed unless there is an abuse of process. And D, the petition should be stayed or dismissed absent countervailing factors. Now, let's start with the Hong Kong courts. How would the Hong Kong court apply this? Do we have any volunteers, or is the Hong Kong approach A, or is it D? James, would you like to try?
I think the answer is between A and D, depending on who's the presiding judge really. So basically, A is the established approach, where the court has the discretion to see if there's a bona fide dispute on substantial grounds. And as we've seen, that's Madam Justice Linda Chan's recent approach in her decision, Simplicity and Pharma. D is the position in Guy Lam. So basically, the petition should be stayed or dismissed unless there's countervailing factors. So abuse of process, that sort of thing. So that is something that Mr. Justice Harris has decided in the Agile Wiggins case. So yeah, the law is still sort of in flux when it comes to arbitration agreements. So it really depends on what happens in your particular case. So the answer is sort of between A and D.
So how about Singapore court? Why don't you complete that with the answer? What about Singapore and English courts?
Okay. I think the English court it's quite straightforward. So that's B, because the law hasn't changed since software estates. So you need exceptional circumstances to be able to overcome the staying or dismissing of a winding up petition. And then for Singapore is C, because they departed from the exceptional circumstances test. They adopt the abuse of process test in NI group.
Thank you. So this scenario actually follows the Bakar Chong scenario. And the next scenario is actually the anti-pharma scenario. Do we want to talk about it? I think the point we want to make here is like options are the same. So the answers are the same. How will Hong Kong decide? We don't know. But the difference is here, the case there is the arbitration agreement. This stat is actually undisputed. There's a cross-claim. The cross-claim is related to a separate but different agreement. And the question is, how do you deal with this? So obviously, Madam Justice Linda Chan says that the cross-claim has no substantial grounds and no bona fide dispute. So she picked A in this approach. So that's the answer to that. So let's go to the next slide, which is quite important as we conclude on the practical tips.
Right. So this is sort of where the practical parts of the webinar is trying to address. So I think if there's something that you want to take away from today as a practitioner, I think this is something to bear in mind. So I think the bottom line is that there's really no one-size-fits-all solution when it comes to winding up and also your choice of DR clause. When you advise your client, we have a whole list of factors that you really have to consider. Not just at the debt recovery stage when you already have a dispute, but actually as early as when you draft the contract. So for future disputes, there are some things that you really have to keep in mind. And the first thing to really look at is where the company is located, right? Because we really looked at the insolvency regime in the UK, in Hong Kong, in Singapore, but the company may be based elsewhere. So the insolvency regime that you're looking at might be an entirely different one that we haven't looked at. And those jurisdictions might not have looked at the cases that we have. So they may actually have entirely different approach when it comes to a petition debt versus the dispute resolution clause, whether it's an exclusive jurisdiction clause or an arbitration agreement. And secondly, I think this is something you need to bear in mind is what is the DR mechanism involved, right? Because if it's exclusive jurisdiction clause, I think the position is quite settled in Hong Kong as per Guy Lam, but if you have an arbitration clause, it's quite different. And this is sort of a general drafting tip. So if there's some sort of dispute that you think you do not want to refer to arbitration, or there are some scenarios where you want to keep the option, then you might want to think about what kind of dispute resolution clause is appropriate for your case. So for example, in England and Wales, you can actually have unilateral option to arbitrate. So those are usually useful for facility arrangements where the lender might want to go straight to the court to get a summary judgment. And they might also want to retain the flexibility to enforce the decision in different jurisdictions. They don't want to be bound in one jurisdiction. So if you have these unilateral option to arbitrate clauses, there may be room for you to argue that because there's a DR clause, it's not a straight arbitration agreement until an arbitration has been submitted at the option of the lender. That the debt can go straight to the insolvency proceeding. There's no basis for the debtor to try to dispute that by relying on the Lasmos or the Guy Lam approach. But that's something that you really need to take specialist advice on because in some jurisdictions like China, you can't enforce a unilateral option to arbitrate. So it's really on a case-by-case basis, and you really have to think about it carefully to see how you structure the DR mechanism.
Because we start.
Oh, yes.
Yeah.
So I think we have 5 more minutes. Try to wrap up as quickly as I can. So the other thing you have to think about is whether there's a realistic claim for the creditor, and also whether the debtor actually has any reasonable defense or cross claim, like a bona fide defense. Because if there is a bona fide defense and you pursue the petition anyway, you can actually have indemnity costs against you, or you may be liable to a malicious prosecution tort claim, as Dayang court has talked about. You should also try to find out if the debtor has other creditors and if they're taking enforcement actions, because the court has mentioned before that they'll need to see if the winding up petition is for the benefit of the creditors as a whole. So if you're also pursuing the claim alongside other creditors, there may be more reasons for the court to wind up the company, right? Versus if you're just commencing the claim by yourself, just to use as a means to try to get money back under the petition. And so basically, I think after going through all that and you still want to pursue the winding up petition, then you need to be prepared before the court. You have to prepare comprehensive evidence to persuade the court to make the bankruptcy or the winding up order, because you have to overcome most likely an exceptional circumstance or frivolous or abusive process, which is a high standard under Hong Kong law. So evidence may include there are other creditors also pursuing the debtor. If they're massively insolvent, as Gillian has mentioned, if there's some kind of abusive process defense, that's completely frivolous. Or if there's some sort of misappropriation of assets, if the company is removing assets from the company, if there are wrongdoers in charge, and it might be in the interest to wind them up as soon as possible to get a liquidator to investigate and distribute assets, that could constitute some sort of exception that will invite the court to make a winding up order.
So finally, let's talk about the pros and cons. So James has talked about all the factors we're gonna mention. So I think James, we're going to go forth with talk about the pros of choosing winding up petition.
Sure. I think you've mentioned at the outset that I think using a winding up petition is quite a powerful tool, because especially if the company is quite profitable, it's a going concern. They don't want to wind up the company. They want to keep the company running. Maybe there's goodwill. So I think threatening up to wind up the company could be quite powerful to get a quick settlement of the debt. You can force them to pay quickly. It also eliminates the usual litigation risk, or an arbitration is the arbitrator risk, because you never know what happens if you submit a dispute, what kind of arbitrator you might get in some cases. You don't know how they'll rule in your case. So there's always that risk factor in every arbitration. So you can kind of overcome that if you're able to wind up the company or force them to give you the debt earlier. And then the other pro is facilitating debt recovery in urgent cases that I mentioned. If there are wrongdoers in charge, if they're dissipating assets from the company, you can also go through the insolvency regime to sort of protect your position as a creditor.
As to the cons, the first is multiplicity of proceedings. That's exactly what James and I have faced when we issued a petition and the other side immediately file an arbitration notice of arbitration on our clients. So we have to basically deal with both the arbitration proceedings and the insolvency proceedings simultaneously. And this obviously will lead into time, money, costs. And remember, there's also the risk of the court actually dismissing the case, and that would be a wasted cause. And the need now to really prove the defense is frivolous, and it's a higher standard to prove. And finally, as James has said, indemnity cost order at first cost order. So really think twice before you file a winding petition and use it as a debt recovery tool. But I will still say, like, if you have a case like we did where the debt is acknowledged, or where there's a case where actually it's a judgment debt that you're recovering, it's still worth trying to bring a petition to recover that debt. And so I think as a conclusion, let's just conclude. The law is unclear as to whether the Gillian approach applies in arbitration context, and it will take the Court of Appeal or Court of Final Appeal to decide. Before such clarification, creditors are advised to consider the various factors we mentioned today in deciding whether to bring a petition to wind up the company, and prepare to meet a very high standard. It's safer now to assume that the Lasmos or the Gillian approach applies, and to consider whether there are exceptional circumstances which could justify your winding up. In terms of merits, that's the graph that I showed you. It's a higher standard to prove that the defense is frivolous and borders, it's like an abusive process if the Gillian applies. So anything to add, James? Okay, so I guess that's it. So let's see if there's any questions from the audience here or from
Thank you, Gillian.
online.
Thank you, James. Thank you for the very wonderful sharing and advice. I like the charts very much. I think, well, I know the time is up, but I reckon that there are still a few questions in the Q&A box. Would you mind to deal with them as well?
Sure. So Martin Lee has a question. First, if the petitioning creditor takes positive actions in the arbitration, how might this affect the court's discretion in the winding up? I think Lasmos applies, right? Mm-hmm. And so basically, if there's positive actions and it follows what the arbitration clause requires you to do, for example, start with a negotiation, start with mediation, then court will probably adjourn this and dismiss the petition so that you can go to arbitration. Mm-hmm. Yeah.
But also in the case that we handled, and where we initially commenced a one-year petition proceedings, subsequently, then the debtor company filed a cross-claim in the arbitration. The arbitration proceeded in that case, and I think in that case, even though there were certain steps taken in the arbitration that didn't sort of prevented the company's court to make the decision that it did in NT Pharma to give the time for the debtor company to pay. Otherwise, a winding up order will be made. So I think you just need to meet the threshold question. You know, whichever approach you do, it's really the existence of the arbitration agreement and whether you've taken steps to commence it. So even if there are certain actions taken in the arbitration subsequently, that doesn't seem to really affect the company's court discretion that much, at least as per Madam Justice and the Chan's decisions.
Yeah, I think it really depends on which approach is applied. So apart from Shandong, are there any other cases where the court adjourned the petition pending the outcome of the arbitration instead of dismissing it? What factors inform this choice, dismissing or adjourning pending an arbitration? Well, interestingly, in Bakar Tong, there's a discussion by Madam Justice Kwan talking about where she thinks that she doesn't think that discretion should be invariably exercised in favor of granting a winding up bankruptcy order, even if there's no bona fide dispute. And she quoted Halmat, a case in Halmat, and where Justice Rogers suggests that if a company wished to stay winding up proceedings, for example, but there's no bona fide dispute, he can suggest that the court can still give a short adjournment for him to file evidence to show a bona fide dispute. And even if there's none, then you can expect the court to ask you for an undertaking to proceed with arbitration. So sometimes the court will give you a chance to adjourn the case. For example, in our case, there's plenty of adjournment for the client, for the parties to negotiate it out and see, because we have a massively solvent company versus a debt that is undisputed. How do you do? So obviously there's an adjournment rather than a dismissal. So these are some of the factors.
I'll just probably add that whether the outcome of the arbitration, at least in the cases that we've seen, and also from the judge's principles, it doesn't really affect whether the petition should be dismissed or continue per se. The reason why the petition is adjourned for the arbitration is because of the underlying principle that the debt is subject to a dispute that should be resolved in the parties' agreed dispute resolution mechanism. So in this case, arbitration. So the outcome of the arbitration in itself, it doesn't really affect whether the court should exercise the discretion to adjourn the petition. And also, even if the arbitration has been concluded, that in itself, it's not something that would really affect how the court will see it. They're merely following the previous decisions, and as long as there's a dispute that should go to arbitration, then they will stay or dismiss the petition in this case.
I think the last question is actually answered in our presentation. As a matter of binding precedent, the ratio of the CFA in GILAM is clearly directed at EJC only. They did not rule on the arbitration clause. Does this mean the CFI judges are bound by the CA/established approach as per Linda Chan?
I think this is a difference in interpretation by the judges, as we've seen in the recent cases, right? Because Mr. Justice Harris thought that the CFI is bound by a finding in the CFA in GILAM that it also extends the arbitration agreements. And then Madam Justice Linda Chan said that GILAM hasn't decided on the issue for arbitration agreement, as we've seen in the Simplicity case and also anti-pharma. So it really depends on how the judges have interpreted whether the GILAM decision is extendable to arbitration agreement, and there's sort of a diverging view on that in the CFI right now.
Thank you, Gillian. Thank you, James. Is there any other question from the audience?
I have a question from the floor.
Or from the floor, yes.
My question is, after reading the judgment from Justice Linda Chan, would you consider Hong Kong as a less arbitration-friendly jurisdiction compared to other jurisdictions? Is Hong Kong lagging behind?
Thank you for your question. The question is whether Madam Justice Linda Chan's decision shows that there is not so much of a pro-arbitration approach. I won't say so, because we can see that in the a lot of Madam Justice Mini Chan's judgment. We're still very pro-arbitration in Hong Kong, and the issue that is faced by Madam Justice Linda Chan is, I think she's trying to do justice to the parties involved. For example, in the anti-pharma case, where when the debtor really put up a counterclaim or a cross-claim that is not substantiated, she just wants to be fair in the approach and try to give a chance, rather than dismissing the petition, saying that actually you shouldn't treat the payment in as a security for the arbitration case. And she also thinks that there's no relationship between the debt claimed in the arbitration and the debt she's facing here. And so she basically, she isn't saying that Hong Kong is not a pro-arbitration jurisdiction. Yeah. Any questions? So I think that's about it.
Yes.
Simon?
Yeah. Thank you, Gillian, James again. And with no further question, I think that concludes today's webinar. And thank you everybody for participating in the webinar. And before I conclude, I would like to highlight that we will be sending a link to all of you to provide your feedback on today's webinar. And with that, thank you everyone for attending today's webinar. That's all for now. Bye-bye.
Thank you.